It always seemed to me that there's a political component associated with civil forfeitures in the sense that the prosecutor can turn around at a particular time and say that the officer was responsible for X amount of money coming in that would fund not only the activities of the prosecutor's office, but also local law enforcement agencies. Mm-hmm. How does the money situation work out these days? In other words, money that you get as a result of a civil forfeiture, what happens to the money?
Well, the money comes in, it's first given to the county treasurer, and it's held in escrow until we get a resolution of the case. And once the matter is resolved, if the money is forfeited, if the money was taken by the county prosecutors, detectives themselves, it goes to our office. If it's taken by a local municipal police department, they get a bulk share. Usually 75 to 85% of the money will be distributed on a biannual share to the local municipal police departments.
So there's an incentive then for local police to be trying to forfeit cash assets of criminal activity?
Well, there is an incentive, yes. I mean, civil asset forfeiture is a pretty important component of the criminal practice, and the money that goes to the local police departments does provide some assistance to them. It's typically a very small percentage of their operating budget, and the money is tightly controlled by guidelines from the Attorney General's office. They can't just spend it on anything they want. No pay, no benefits, no items that are normally part of the annual operating budget. It's money that is reserved exclusively for extraordinary expenses, such as a sudden need for some new equipment,
right,
or for training and other activities like that that go to the police. I mean, if they need to send a detective down to Quantico to take a forensic computer training with the FBI, they can dip into that. Or if they want to fund a special training program for local DV counselors, they can dip into the forfeiture funds for that.
My recollection is that there was a case actually involving the Salem County prosecutor years ago where these guidelines had not been particularly well established by the AG's office. Mm-hmm. He took some of the money and went to some event in California with the first assistant and wound up getting prosecuted for it. He got PTI and all that, but I think that really kind of spurred the Attorney General to put very strict guidelines on what can happen to the money. Now, can we talk for a second about assets that are not liquid, cars, jewelry, and most importantly, firearms?
Right.
Can we talk about that a little bit? This is stuff that's it's not per se contraband.
No, it's not.
But by the same token, it does have some value associated with it. How do you handle that, and how do you split the money from those proceeds, assuming you can sell the asset?
Well, I'll discuss firearms first. We don't get involved in the civil forfeiture of firearms. Okay, firearms is dealt with by a different part of our office. We don't include it in civil forfeiture. Typically, the firearms we bring in are illegal. They're unregistered. They've been used. They're defaced or they're unregistered. They're not going back because they are per se contraband.
Right.
Okay. The only time that I'm aware of when firearms will be seized but could be eventually returned is in a DV situation where weapons are seized. As part of any DV case, we have to seize the weapons. They are held and then the matter is resolved, and the individual who's the lawful owner of the firearm can petition to have them returned, and that happens on some occasions from what I understand. As for other assets, typically what we get are automobiles,
right,
flat screen TVs, computers, cameras. We don't get a lot of jewelry and things like that because they're very difficult to dispose of. But discussing vehicles, we take a vehicle in. If the vehicle is in good condition and the police want to put it on the road as an undercover car or paint it up as a DARE vehicle, right, and we forfeit it, we will give it to the local police department. If they don't want it for whatever reason, the vehicle is not in good condition, and it's just not roadworthy, they tell us to auction it. We will put it up for the annual auction. Whatever money we get in is almost like cash being brought in for forfeiture. It's distributed to the local police department.
Now, who's responsible for making the efforts to make sure that the title is vested in the person who's been charged with the crime, as opposed to some innocent person who's just it's titled in that innocent person's name, but was utilized for some criminal purpose?
Are you talking about the innocent owner defense?
Yes.
Okay.
And specifically in the context of vehicles.
Well, the bulk of the vehicles that we take in are registered to someone other than the defendant.
Right.
Okay. And when we get that situation, what we have to do is, first of all, evaluate the facts of the case. We read the police reports. And most importantly, what I do is I actually take a physical look at the car. Because what we're concerned about mostly is who is using the car more than not. I know that the car is registered in the name of the grandmother or the aunt or someone like that, but really it's the defendant who's using the car on a day in and day out basis. The defendant's clothes, the defendant's papers, the defendant's other personal belongings are in the vehicle, and we can demonstrate by the contents of the car that the defendant is really almost exclusively using that vehicle, in which case the court then would declare that person the beneficial owner, and the innocent owner doesn't have the defense.
Would you also have to show that the vehicle was used in the course of the commission of the offense?
Yes, that's hardly ever difficult. I mean, the car is taken because it was used in the commission of a crime, whether it's in eluding, drug distribution, arson, homicide, whatever. If the car was part of the crime, that is why we take it. You know, we're just not out, hey, we like that car, we're going to take it.
What about real property, buildings and actual mud, you know, that they build on? What do you do with that?
We really avoid in Mercer County trying to take real property because we don't want to become a landlord, we don't want to become a real estate agent. We have done it on occasions, and what we do is when we file for property, the one time I did go for a property, we ended up resolving it as part of the criminal plea. The person agreed that they would sell it, and then we'd split the equity 50-50.
Got it.
So we didn't actually get title to it. We let the defendant keep the title, and then he sold it. We had to, of course, get final approval to make sure it wasn't sold below market value. But once they found a buyer who wanted to buy it at market value, we consented, and then we split the equity 50-50 after all the taxes, fees, and title expenses were paid.
Now, you raise a very interesting point, and everyone knows that RPC 3.8 really treats prosecutors as a kind of a special breed. Prosecutors are not normal advocates. Your function is basically not to merely seek convictions, but to do justice. And I know that you, as a professional prosecutor, seek to do individual justice in individual cases. No doubt about that in anybody's mind. The problem that you run into, or I can see as a potential difficulty, is you have a very close relationship between a civil case, which is going on in your part of the office, and a collateral criminal prosecution going on simultaneously. And at some point, these are going to converge, and there's going to be discussions, I would think, for a global settlement of it. So how do you avoid getting to a situation where you could be accused of utilizing a criminal process to get an advantage in a civil proceeding or vice versa? You see that the possibility of an ethical issue.
We're aware of it every day. Okay.
So how do you treat that in your office?
Well, the first and foremost is we never condition a criminal plea on agreement to forfeit property. Okay? No matter what, if the defendant says, I'll take a plea, I'll do a plea, but under no circumstances am I agreeing to forfeit that property, we say no problem. You can do the criminal plea, we'll take care of the forfeiture later. Many times, though, what happens is the defense attorney will invite us to enter negotiations that include the forfeited property. It becomes a bargaining chip in the criminal plea negotiations. That's done at the request of the defense attorney with the full knowledge of the defendant.
So not initiated by your office?
We oftentimes will say, if you're willing to include forfeiture as part of it, we're willing to negotiate. But again, we never condition a plea agreement or any plea negotiations on acceptance of an agreement to forfeit certain property.
Now,
but by common practice, everybody knows you can do it together.
Okay.
And that's just the way it is. I mean, the defense attorneys know it, the prosecutors know it, it comes up, it's freely discussed, but again, a criminal plea is never conditioned on specific forfeiture of property.
Now, all this presupposes that you have attorneys on the other side, which make it easier to deal with from a professional standpoint. But I imagine you have to deal with a lot of pro se defendants as well. Is that true?
In the criminal side,
yes.
No.
I don't mean that. I mean in the forfeiture side.
In the forfeiture side, yes. Many individuals come in pro se in forfeiture.